Good afternoon, members. It is the appointed time and the quorum is present. I call to order the meeting of this Bills Committee. Subsequent to the previous meeting, we have received some papers issued by the government dated the 20th, a reply concerning the matters concerned, the concerns raised as the previous meeting on the 28th of November. A response has been issued. That is paper CB brackets 21076, 2022 brackets 01. And just this morning, we have received the response from the government concerning the questions raised by members at the meeting on the 9th of December 2022. In relation to the two responses, as well as the letter sent by Mr. Lai Tung-kwok dated the 6th of January this year, these papers have been forwarded to members. A written reply is pending from the government. Now I extend a warm welcome to the officials. So first of all, some housekeeping matters. On the previous occasion, we have been conducting the clause-by-clause scrutiny of the bill. Up to clause 63. May I refer you to page 127 of the Chinese markup copy. That is page 127 and page 122 of the English version. So may I suggest this? So the response dated the 9th of December was just submitted today. And I think members do need time to study and digest the contents. Since we were in the process of the clause-by-clause scrutiny of the bill, I suggest we resume clause-by-clause scrutiny first, and then we can go back to the response of the government concerning the issues raised at the previous meeting. Well, depending on the progress, I think we need at least one more occasion, one more session of the meeting to complete the clause-by-clause scrutiny. So I think we can discuss the government's response on issues raised at the meeting on the 9th of December on the next occasion. And also for the government to provide a response to the letter of Mr. Lai Tung-kwok dated the 6th of January on the next occasion. And meanwhile, members may consider whether amendments have to be moved concerning the bill. So that's my suggestion, Mr. Ho Kai-ming. Thank you, Chairman. I share your views. Thank you. If there are no objections, then we shall resume where we left off last time. That is clause 63 in the bill. And also, please refer to the Chinese and English version of the markup copy. It is clause 60 in the blue bill. I suppose Ms. Wong will continue to walk us through the bill. Thank you. Thank you, Chairman. So we were scrutinizing the Residential Care Homes Legislation Miscellaneous Amendments Bill 2022. Now, Clause 64. After Section 10, we are adding the new Division 3 sections at Parts 2 and 3. We have the new Section 10A and 10B and other sections as well. This is mainly about introducing the requirements of a responsible person. The relevant requirements are identical to the relevant amendments to CAP 459. Now, 10A, license applicants to propose responsible person for RCHD. The provision is identical to the newly added provision under CAP 459, that is CAP 459, Section 11A. Yes, members, if you have any questions concerning a particular provision, please press the button. Please continue, Ms. Wong. Thank you. The new Section 10B, certain operators must propose responsible person on renewal application. The provision is identical to CAP 459, Section 11B. Moving on to page 129 of the markup copy. New Section 10C on how to propose responsible person. An applicant or an operator is required to provide some information on proposal of responsible person. It corresponds to CAP 459 11C. Next, the new Section 10D. It sets out the duties of a responsible person, which corresponds to CAP 459 Section 11D. Next, the new Section 10E. Ms. Doreen Kong. Chair, I have a question pertaining to these provisions. I understand these provisions mirrors the RCHE ordinance. But I think in terms of duties of a responsible person, RCHD is different from RCHE. But we have totally identical sections 10A to 10D to 10C. Now, for the duties of a responsible person of a RCHD, from a social welfare perspective, are the considerations the same as that of the RCHE? Well, I think because persons with disabilities have special needs because of their bodily condition, so why are the requirements the same as that for RCHEs? Thank you, Ms. Kong, for your question. Section 10D is about the duties of a responsible person. That responsible person is responsible for the operation of the entire home. Now, Ms. Doreen Kong mentioned the difference between RCHD and RCHE in terms of the operational level. We have to consider the types of disabilities suffered by the residents, whether it is physical disability or mental disability. I believe that there are indeed very different requirements for the care for these residents. However, for the responsible person, he or she would be responsible for the supervision and the management of the entire home. That is in terms of the services offered to the residents, the services offered to the residents by the frontline staff, certain safety requirements and safety standards are met. So that's why in terms of the drafting of the legislation, the provisions are identical with that of RCHEs. On the operational level, however, in terms of the different needs of the residents, there will be differentiation. On the bill, however, we are not going into such details. as to specify the operational details of certain homes. So we have two. So the bill will amend two ordinances. So there are parts where RCHD and RCHE ordinances would receive the same amendments, but there are also other amendments to the ordinances or regulations beyond the bill. Is that true? Under Secretary, Chair, to a certain extent, yes. For those details which we don't have to change, they won't be mentioned on the bill. Now, for elderly persons, some of them are not able to conduct self-care. So to a certain extent, they are similar to persons with disabilities. Concerning manpower requirements, when we come to Cap 613A, there will be a discussion on this. For RCHE, most residents would stay inside the facilities. They would rarely go out. For persons with disabilities, however, some are residing in midway homes or similar facilities, and they would go out to work or receive training. So we are not requiring the staff to be on the premises, but rather on duty. So there is a difference. We shall point out the difference when we come to that part of the bill. Ms. Kong, thank you. Chair, you were very clear. The point is we have to ensure that people with different needs should get the care they deserve. So I look forward to hearing the administration explanation on how the RCHE and RCHD are different in this regard. Okay, please continue, Ms. Wong. Now we have come to page 130 of the markup copy, new section 10E, on fit and proper requirements for responsible person. In considering whether a person is a fit and proper person, the director must pay regard to all relevant matters, including the matters set out in Schedule 2. Now, may I refer you to Schedule 2, page 155. The factors to be considered are identical to that listed out under Cap 459, including whether the whether the persons are proposed that had a criminal record, and also past application for license or renewal, or whether he is a subject of undischarged bankruptcy. These requirements are identical to that under Cap 459. So let's return to page 130 on the markup copy. This is new section 10F concerning the change of responsible person as required by the director. It specifies that the director may, by written notice given to the operator of a residential care home for PWDs, directs that the responsible person cease to be such a responsible person if he is no longer a fit and proper person or he has failed to perform any of the duties. It mirrors the relevant provisions under Cap 459. Mr. LAI Tung-kwok.
Chair, under item 5, the outgoing responsible person ceases to be the responsible person of the care home effective immediately. So the operator of a care home receives the director's notice. It takes time for the operator to find a substitute for the role. What happens during the gap? The notice reaches the operator. There's supposed to be a 7-day window or something. So there's a gap of 7 days or so. What happens during the gap? Ms. Vega Wong, please. In these cases, the director allows the operator to nominate a management officer to run the care facility for the time being. The operator also has a duty to ensure the care home is run smoothly. Chair, my question is about the gap. Of course, at the operational level, you can always find someone else to help run the care home for the time being. But then my question is, when something goes wrong, the party at fault leaves and no one's doing the job. So this is a question of flexibility. Mr. Lai mentions the possibility of a gap. Indeed, this is possible. Say someone commits a crime under the residential care homes ordinance. If a crime happens in the gap, the social welfare department will try to shorten that period as much as possible. There is still a duty on the operator during the gap for running the care home. There are unforeseen developments. Say you may have a responsible person resigning all of a sudden. Even if this is not done at the request of the director, then you have a gap. The social welfare department will do its best to shorten the period by, for example, speeding up the approval process so that an alternative responsible person can be nominated and approved as much as possible. Mr. Lai, the government anticipates the possibility of a gap, so the drafting should do something to address this gap. Say you have a responsible person getting informed they're no longer suitable, no longer going to fit a proper person as a responsible person. It should be written into the law saying that someone else will automatically step in to serve as the responsible person. The social welfare department may be very hardworking, but there is a gap under the law or under the provisions in this bill. Deputy Secretary, please. A gap is hard to avoid because the responsible person is a natural person. The operator, on the other hand, may be a legal entity or legal person. So we cannot have the operator step in automatically. The operator will have to appoint someone, another natural person, and we need that person's consent. The responsible person has legal duty. This person has to take responsibility by becoming the responsible person. And then the information of this candidate goes to the SWD. Having someone from the operator step in automatically will create operational difficulties. Mr. Lai? Chairman, the explanation offered by the government is all the more reason that we need someone to fill in automatically. Look at our committee. We have a chairman and a deputy chairperson as well. You need something built into the design to anticipate this scenario. In the bill, we're talking about legal responsibility. This is to be distinguished from the operational problem. Operationally, you can have someone fill in right away, but then in the law, you have to do something to anticipate this scenario. Deputy Secretary, anything else? Nothing. We move on. Mr. Rincon, please. Chairman, I want to follow up on the point raised by Mr. Lai just then. The operator also has a duty to do something, but that duty is not spelled out in the bill. Under Section 10D, that's the duties of the responsible person. The government just said the operator also has responsibility for running the care home. When we don't have a responsible person, what's the responsibility of the operator? Does the operator undertake the same responsibilities as the responsible person? I draw members' attention to the Chinese version of the marked up copy 0145. Section 22B to be inserted. This has to do with the legal duties of the directors of the partnership. Depending on the type of the operator, when a care home commits an offense, there is liability for the care home. Mr. Rincon. Chair, the part the government refers us to is about something else. That part says that when the responsible person commits an offense, the operator is also liable. But I'm talking about a situation where you don't have a responsible person. Sections 22A and 22B mean that when the responsible person breaches the law, the operator is also accountable. But just then, Mr. Lai is talking about a scenario in which you don't have a responsible person. And the government told us there is also responsibility on the shoulders of the operator. Sections 22A and 22B are not helpful in this case. Section 22A is about the liability of the responsible person. If the operator of a care home commits an offense, and the responsible person commits a breach at the connivance of the operator, so the wording here says that if the operator commits an offense and something happens, so that section shows there is liability for the operator. Chair, I don't want to take up everyone's time. The same issue is there with the amendments to the Residential Care Home Elderly Persons Ordinance. Section 22A and 22B apply only when you can point to a specific responsible person. But we are here talking about a situation where you don't have a responsible person. When that's the case, who's to be held accountable? In that case, sections 22A and 22B do not apply. Can the government think this over? Can the government offer an explanation right away, or can you give us an explanation later on? So, liability of the operator. Is it the same as that for the responsible person, or are they two different matters, Deputy Secretary? Operator is defined as the license holder. some offenses are directly related to the license holder. The existing ordinance, Section 21, for license holders in breach of the conditions, in terms of caring for, running or managing, controlling the residential care homes for elderly persons. In these cases, when an offense is committed, the license holder is to be held accountable. In the elderly care home industry, the license holder is very often a legal person. What we are trying to achieve here is that not just to hold the legal person accountable. When you have a poorly run care home, we also need a natural person to be held accountable. And that's why we are inserting this section about the responsible person into the bill. There are already rules on how a care home should be run. Chair, the same problem is found in the legislation about the persons with disabilities. In 0143 of the Chinese marked up copy, that's a section 22, offenses related to the license and certificate of exemption. We're focusing on the technical amendments at this point. When a license holder or a holder of the certificate of exemption commit an offense under Section 22, bracket 1, bracket 3, the responsible person will be held accountable. And under Section 22B, liability also arises. Mr. LAI Tung-kwok. Section 22A is to be inserted. That means it's not there. Section 22A says that if an operator commits an offense under the ordinance, and this is proved to be something that can be attributed to the neglect of the responsible person. So there is a condition here. If you don't have a responsible person here, the entire section does not apply. That's why I was saying this is a gap in the law. We need to anticipate all these possibilities. If you go ahead with this provision and something goes wrong, there's nothing the government can do. Can we fix this? And if we can, how do we fix it? This is something for the government to consider. The government should consider what to do when a gap appears. The government has agreed to look into this issue. This may take time. Undersecretary, Section 22A on page 0145 of the Chinese marked up copy. When an offense is committed at a care home, the operator is breaking the law. And if you have an employee who knows this, this person is also liable. So I just want to clarify this. The operator is accountable, and the responsible person will also be liable. That's the Section 22A. Whereas Section 21 is about the operator.
Let's resume. Ms. Wong. We go back to page 131 of the markup copy. That is the new section 10G. On the change of responsible person because of death, incapacity, etc. Because of these reasons, if the responsible person of a RCHD becomes incapable, a replacement can be proposed. This also corresponds to CAP 459. Mr. Ring Kong, 10G 1C, the Chinese version. Now, the responsible person would cease to be such a responsible person when he or she ceases to be a management officer of the operator of the residential care home. Now, if the responsible person ceases to be a management officer, he will be replaced. That is the Chinese version. It doesn't make sense. Now, the English version is much clearer. It says, if the responsible person ceases to be a management officer of the operator of the residential care home. So that is, his appointment has been cancelled. So I think the Chinese version should be amended to become a 被停任. That is, ceases to be the management officer. Under Secretary, Chair, I think the subject in the Chinese version of 10GC is that the responsible is no longer the management officer. So the subject is the responsible person. So I think the Chinese and English versions essentially means the same thing. Chairman, allow me to explain. 10G. So A, if a responsible person dies, that's very clear. B, becomes incapable of managing because of mental or physical incapacity. C, no longer the management officer. That's very strange. I can understand the English version, but not the Chinese one. Well, let's say if Mr. Tony Jie is no longer the chairman of this bills committee, the meaning is very clear. That is, the person is no longer the management officer. So the subject here is the responsible person. A responsible person who has ceased to be the management officer of the care home. Let's say he resigned. So it simply means he is no longer the management officer of the care home. It's not necessarily so that his appointment was terminated. That is one of the scenarios only. He can cease to become the management officer on his own accord or passively. So management officer means the operator of the residential care home, but not the responsible person. It seems that the Chinese version is quite confusing. So according to my understanding, that is the management officer who ceased to be the operator of the care home. While the management officer can be a legal entity. Well, sometimes we often have a debate over the wording of the Chinese version of the bill. We have encountered such scenarios many times before. So Ms. Doreen Kong thinks the Chinese version is a bit misleading or confusing. However, after reading it again, you may find it clearer. Should we leave it at that? Chair, may I make a suggestion? ceases to be a management officer. Well, he's not being terminated as the management officer. In the English version, ceases to be can also be passive. So the English version is quite clear, but in the Chinese version, it's simply wrong. And it carries different meanings from the English version. Well, the word 停任 in the Chinese version, well, I think it can mean he ceased to be or is no longer the management officer for whatever reason, either actively or passively. So DOJ, please. Well, may I explain the word as ceases? According to the English dictionary, Merriam-Webster, ceases simply means no longer continue or come to an end. It doesn't connote the idea of active or passive. So either it can mean both actively or passively as cease to be the management officer. Mr. LAI Tung-kwok. 10G, brackets 1. The responsible person of a residential care home for PWDs ceases to be a responsible person when he or she. Well, in the Chinese version, there is the word the above mentioned, which seems that it refers to the previous reference of death, incapacity, and etc. Well, however, I may think that the above mentioned refer to the previous sessions, like from 10A to 10F. Or in the English version, however, it is very clear. The Chinese version, however, seems very misleading. Well, it boils down to the different expressions in the Chinese and English versions. Well, the word 上述 in the Chinese context may means a lot of things. Mr. Choi. We are looking at each clause individually. So under the context of 10G, such or above mentioned simply refers to a responsible person mentioned earlier on. Well, yes, otherwise you would have specified the particular session or provision that you are referring to, right? Dr. David Lam. I also have a question concerning 10G, brackets 1C, ceases to be a management officer. Well, should we construe the word from the perspective of acting as or become? Well, I wonder if there are any prevailing interpretation on this word. Well, it depends on the context, actually. In this scenario, it means acting as. Well, in other legislation, however, it may mean appointed as. So in that context, ceases to become will mean that the appointment has become ineffective or invalid. Well, I think we can do it in a simpler way. That is that he is no longer the management officer. Well, we will go back and study it, Chairman. Ms. Wong, please continue. Moving on to page 132, the new session 10H, change of responsible person in other circumstances. This is a new session, new provision. Specifying that under circumstances other than set out in sessions 10F and G, upon serving a notice to the director, the care home can change the responsible person. It corresponds to Section 11H under Cap 459. Please continue. Page 134 of the markup copy, the new Section 10J. The requirements for the operator to report certain events. These include a charge laid against the operator or the responsible person for an offense in any place, conviction of an offense, becomes an undischarged bankrupt, or enters into a composition or scheme of arrangements with their creditors, or they have become the subject of a binding up order, they have to report to the director. This also mirrors the other ordinance. Now we have come to page 135 of the markup copy, the new Section 10J. My apologies. We are already at page 137 of the markup copy. Amending the existing Section 11 concerning the application and issuance of the certificates of exemption. Cap 459 does not have this provision. This is technical in nature. That is to replace the operator with replacing license holder with operator. Mr. Ring Kong. So what about Section 10J? Did we skip 10J? Well, 10J is on page 134. That is issues to be reported by the operator. We have covered that. So when we were at Section 10I and 10H, Ms. Wong has already explained the issues to be reported. So she has covered 10J as well. She did cover 10J, but there may have been some confusion because it may seem to you that we have skipped 10I. Well, actually, 10H, I, and J are all related. So unless you have any questions on 10I, 10J would have been covered as well. No questions then. Thank you. Ms. Wong, please continue. Page 139 of the markup copy. Amending Section 12, the existing Section 12, renewal of certificates of exemption. We replace a person holding a certificate of exemption with the operator. The other provisions remain the same. Let's continue. Page 141 of the markup copy. Amending the existing Section 13. We are replacing person holding the certificate with operator of the existing home, with the other provisions staying the same. And then page 142 of the markup copy, amending the existing Section 18(2)(a). It specifies the circumstances under which the director can serve a remedial notice. These are just technical changes.
So there's a change in the Chinese wording here. Page 143 of the marked up copy, we touched on this just then. This is an existing provision. Offenses in relation to licenses and certificates of exemption. Here are some technical amendments to the wording, no change to the substance. Please go on. Page 145 of the Chinese marked up copy. Inserting sections 22A and 22B. We briefly touched on these two sections just then. Section 22A. If the operator commits an offense under this ordinance, and it is proof that the breach happened with the consent of the responsible person is also liable. This corresponds to Section 21A under Cap 459. That is the amendment to Cap 459. Section 22B, liability of directors, partners, etc. Again, liability. The amendment corresponds to Section 21B of the amendment to Cap 459, legal advisor. The proposed Section 22B, say you have a body corporate. This body corporate commits an offense. Someone in that body corporate connives at the breach, that person is also liable. Someone concerned in the management of this care home, employees are covered in this case. Will the government follow the practice of some other existing legislation? That is, can we have some exemption statutory defenses for employees? Say you have an employee follows the instructions of the employer, and the employee has no part in the decision. In such cases, can we have a defense or immunity for the employee who's just following the instructions? We sought legal advice while drafting the provisions for the proposed amendment. When a body corporate commits an offense, the body corporate is liable. When it's proved that the director consents to or connives at the offense, or someone concerned in the management of the care home consents to or connives at the offense, that person is also guilty of this offense. The legal advice we received is that based on the way it's drafted now, the burden of proof lies with the prosecution. The prosecution has to prove the director or a person concerned consents to or connives at the commission of this offense. The prosecution has to adduce sufficient evidence. All the elements of the offense need to be proved beyond reasonable doubt. And then the judge can find the defendant guilty. So for this section, there's a high threshold because it says that you need to prove there is consent or connivance. So there's no need to insert additional statutory defenses. We've looked at similar legislation like the guest house and hotel accommodation, and then also for the tourism industry ordinance, Section 21A. With this section, we target the decision maker. The provision says person concerned in the management. So we're talking about the management, not just some ordinary employee. This is someone involved in the decision-making process. We target these people. Now, based on the legal advice, we are drafting the clause saying that this has to be a director or someone concerned in the management of the care home. So this has to be someone in a management role at the care home. This is a decision maker. There has to be sufficient evidence showing this person consents to or connives at the offense being committed. So we don't need to introduce any statutory defenses. We've looked at similar examples from other legislation. So that's our thought process. Anything else from legal advisor? No. Mr. Ring Kong, please. My question has to do with Section 22A. A responsible person consents to or connives at an offense. You need some kind of behavior to show that someone connives at an offense. Now, what if someone tacitly allows something to happen or someone turns a blind eye to an offense? Do these amount to consent or connivance? Under Sections 22A and 22B, we have this phrase, a person concerned in the management of a care home. Has the law or the bill spelled out what we mean by a person concerned in the management of a sole proprietor or a body corporate? Elsewhere in the bill, it says that someone concerned in the management of a care home is also liable. So is the accountant also liable, or does an average manager at a facility held liable? Bracket 1 of Section 22B, it says a sole proprietor. A person is also liable when this person is concerned in the management of the sole proprietorship. If it's a sole proprietorship, we expect just one person managing the sole proprietorship. Can the government give us an example showing what they mean by a person concerned in the management of the sole proprietorship? Ms. Vega Wong. As the chairman suggested, let's go through the clause-by-clause scrutiny before we address the reply to the members' concerns, or we can jump right into the follow-up matters. When we say person concerned in the management of a body corporate or a sole proprietorship, we're drafting in this way by following other ordinance, lift and escalator, Section 141 of Cap 618, and private columbarium, Section 100, and also private healthcare facilities, Section 94, and also the fire safety bracket industrial buildings, Cap 636, and Section 46. Similar wording is found in the pieces of legislation I just mentioned. When a term is not specifically defined, the ordinary meaning applies. Someone isn't treated as someone concerned in the management if this person happens to be a manager. We look at the evidence. Does the evidence show this person manages the care home? That's something we look at. We look at the facts of each case. we will look at this person's roles and responsibilities, whether this person takes part in major decision making. That's another factor we look at. When it comes to prosecution, the prosecution has to adduce the evidence showing a particular person is concerned in the management. As the member rightly pointed out, when you have a sole proprietorship, you have the sole proprietor. But for some sole proprietors, they engage professionals in managing a care home. So in those cases, you have a sole proprietorship, but professionals are involved in the day-to-day management of that care home. We want to cover those cases as well in our amendment. What about tacitly allowing a breach to happen? Is tacitly allowing an offense an example of consent or connivance? We have to look at the facts to determine which is the case. Mr. LAI Tung-kwok. Just then, the Deputy Secretary mentioned other pieces of legislation as examples showing the phrase concerned in the management is used. My question is, in those pieces of legislation, do those laws also say sole proprietorship? If sole proprietorship shows up in those laws, then we have examples we can follow. But then if those pieces of legislation aren't about sole proprietorship, then we have a different conversation. My colleague from the Department of Justice, Mr. Choi, will tell us more. We may need a bit more time. Jump in whenever you're ready. So for now, we will have to ask the members to wait for a bit. Let's follow up on this point in a moment. We will resume the clause-by-clause scrutiny for the time being. Page 146 of the Chinese marked-up copy, inserting Section 22C. This is about the prosecution deadline for offenses. This is similar to Section 21C under the amendments to Cap 459. A prosecution for an offense under this ordinance may only be started before the end of 12 months after the date on which the offense is discovered by the director. Now, we have to stick to a 6-month window under the magistrate's ordinance. So the proposed amendment will give us a new window. Mr. LAI Tung-kwok, does material date mean 12 months after the enactment of this bill? Assuming this bill is enacted, all the prosecution time limits will remain 6 months, and then we'll have to wait another 12 months before the 12-month prosecution period kick in. Why aren't we having this 12-month prosecution limit take effect right after the bill is passed? Ms. Vega Wong, we are aligning the material date with other provisions of the bill. Once this bill is gazetted, there will be a 1-year window, and then the legislation takes effect. We're just saying that the existing provisions will remain in effect until the bill that is enacted takes effect. Chair, I don't get the government's goal here. The point of this section is about lengthening the prosecution deadline. Now, once the bill is passed, the point is to have the prosecution start within 12 months instead of 6 months. But the section says that you have to wait for a year before the 12-month prosecution deadline kicks in. So why are you pushing back the start of this new prosecution deadline?
Thank you. I understand the member's concern concerning the liability of a responsible person and also the proposal of a responsible person by the owner of a home. These will come into effect upon the material date. So we want to align the requirement. In case of any offenses committed by the responsible persons or the operators, the date would be aligned with the time bar of the prosecutorial period, so that the trade will have an easier time to follow. Ms. Doreen Kong. Thank you, Chair. Section 22C, brackets 1. A prosecution for an offence may only be started before the end of 12 months after the date on which the offence is discovered by the director. So how do you prove that it is on a certain day that the offence was discovered by the director? Do we have to call or write to the director? And I have a problem about the choice of the wording, may only be started. So before the offence is discovered by the director, no prosecution can be taken forward. It's problematic even in the English version. A prosecution may only be started. So what if the offence is extremely serious but is not yet discovered by the director? Let's say someone has committed a grievous offence which is not yet discovered by the director. Why do we have to notify the director before we take action? Director, please. A commissioner, Ms. Wong. Thank you, Chair, and thank you, member. So when we receive reports or complaints about potentially problematic incidents, either from staff or residents or other people, we would send inspectors to carry out investigation, and we would keep record of investigations. So we would follow up any breaches very seriously. Mr. Ring Kong, I think prosecution is very important. You can't just say that you have discharged your duty by saying that we are aware of this and we have taken notes of this. We can't wait until the director has discovered the offence. I think it is a too relaxed approach in terms of prosecution. So any supplements from the government in terms of the word discovered? Mr. Choi? Well, concerning the wording, the offence is discovered. There is a case, there is an authority in 2013, HASAR vs. Wong Wan-sung. In the judgment, the High Court explained the term offence discovered. So through active investigation, a report by others, or a combined approach, the department or the authority has been made aware of the offence. So like what Ms. Wong said, written or paper record is also a means for the director to discover the offence. Chair, we have made reference to Cap 48, the Buildings Ordinance. That is, any prosecution taken forward under the ordinance can be taken forward within 12 months upon after that the director has been made aware of the offense. Now, the private column barrier ordinance also has a similar provision. That is, an offense discovered by the director of food and environmental hygiene. So, to coupling with Mr. Choi's explanation, we think that this provision is clear enough. Mr. Lai Tung-kwok, I agree with Mr. Rin Kong that the wording discovered is problematic. Even if you have discovered an offense, it doesn't mean that you would press charge. The defendants would definitely argue with you how the period is counted. So if the offense took place 2 years ago, by discovering, it would mean that you have discovered the offense 2 years ago. But if you are pressing charge a year later, then it may not meet the may not fulfill the requirement. So I think it really opens up a lot of potential legal challenges. I have another question, though. Under the bill or under the ordinance, are there any indictable offences? If there are, then Section 22C may give rise to another obstacle. For taking forward prosecution under an indictable offense within 12 months, because otherwise, for indictable offense, there is no prosecution time limit. So, Director, can you please explain in details about the choice of the word discovered? You have referred us to a High Court authority just now. Can you give us more details? Well, let's say if you have discovered the occurrence of an offense during the process of investigation, it would occur to you that the offense has actually taken place. So I understand where members were coming from, but actually a lot of legislations were drafted like this. And we have encountered no problems so far. But I promise you we will go back to study your concerns. And also, most of the offences under this ordinance are summary offences. Like Mr. Lai Tung-kwok said, for indictable offences, there are no time bar. However, Section 22C mentions offences under this ordinance, so it would only cover summary offences. So I just want to confirm whether offences under this ordinance are not indictable offences. You said most of the offences, so that means some offences may be prosecuted under the indictable offences. So that would be a huge problem. So if there is a serious offense in the future, can or can you not prosecute the defendant with an indictable offense? So if every offense under this ordinance is a summary offense, then there is rationale for you to include the time bar 12 months. But what about indictable offenses? Director, thank you. As far as we understand, all offences under this ordinance are summary offences. Since members have raised this concern, we will go back and confirm this with the DOJ. Thank you. If there are no more supplements, let's continue. Thank you. Concerning the amendments to the RCHD ordinance, we are now at page 146, and we have covered section 22C. So now we have come to page 147 of the markup copy. An amendment to the existing section 24, a textual amendment, replacing persons holding the licenses with operators and responsible persons. The other parts of the provisions are the same. So now we have come to page 150, Schedule 1, which we have already covered. So we have completed clause-by-clause scrutiny for Part 4 of the bill. Thank you, Chair. Thank you very much.
OK。嗰啲附表一
Schedule 1. Well, Ms. Wong, you mentioned Schedule 2 as well. Do you have anything to add about Schedule 2? Schedule 2 has come into our discussion just now. So anything to add about Schedule 2? Nothing, Chair, because it just mirrors the amendments to Cap 459. That is concerning whether a person is fit and proper. The director has to consider something, including whether there is a conviction record for the applicant and also previous situation, previous application for license and for renewal of license, and also whether the person is a subject of an undischarged bankruptcy order. These are just corresponding amendments like Cap 459. With the Chairman's leave, we have completed the clause-by-clause for Part 4. Now we can move on to Cap 613A, amendments concerning RCHD ordinance. I will give the floor to my colleague. That is Ms. Kwan. Thank you very much. Now we are at page 157 of the markup copy, Clause 75, amendments to Residential Care Homes Persons with Disabilities Regulation. Now, Section 2, interpretation. It corresponds with Cap 459. We have amended the definition for health worker to clearly set out the definition for a health worker. And similar, and unlike Cap 459A, the definitions for nurse and operator, they have been covered in Section 51, Cap 630, and Section 52, 618. So we have deleted the definitions here. Now, Clause 76, amending Section 3 of the regulation, some textual amendments only. Continue. Clause 77, we are adding Part 2A. It covers the new Section 3A to 3I about the registration of home managers. It corresponds to Part 2A of Cap 459A. On principle, the registration system are the same. Now, Part 1, new Section 3A. Factors to be considered by the director for registration as a registered home manager, whether he is a fit and proper person, whether he is capable, and whether he has the qualification. Section 3A sets out that the director may impose additional conditions like continual education. Now, new Section 3B sets out the new qualification requirements for registration as home manager. It mainly refers to the training courses specified by the director, and also he or she has to be a holder of a professional qualification relating to healthcare and social work, or a bachelor or higher degree, and also have worked in residential care homes over the past 3 years, or have worked for 5 years in a care home previously.
Nancy Kwan, please continue. The fit and proper person under Section 3C. These are the factors for the director to consider: criminal conviction, academic qualifications, etc. Please carry on, Ms. Kwan. Section 3D, application for registration. The application goes to the director, and the director has to write to the applicant for the decision. If the application is refused, there has to be a reason stated for the refusal, and the notice has to say the applicant can appeal the decision. Section 3E, renewal of registration. This is similar to an amendment under Cap 459. There's a time limit, and there's a way for the applicant to renew the registration, and there are also the factors for the director to consider in renewing the registration. If needed, the director is also empowered to impose conditions on the renewal. The proposed insertion of Section 3F, once a decision is made, the director has to notify the applicant in writing. If the application is granted, the validity period has to be stated. If it's a rejection, the reasons have to be given, and appeal is possible. This has to be stated. Section 3G. Until the director makes a decision, the registration remains valid until the decision has come out. For renewal validity, the validity is 5 years at most. That's under 3H. Now we turn to Section 3I. Under certain conditions, the director can cancel a person's registration. This is similar to the factors set out under Cap 459. If the registration is obtained by fraudulent means, or this person no longer meets the requirements of registration, or this person contravenes the conditions imposed by the director or fails to disclose certain things, the registration can be cancelled. The applicant can also write to the director requesting that the registration be cancelled. Or this person had in the registration as a home manager at an elderly care home, but then under the legislation for persons with disabilities, the registration will also be cancelled. Section 3J, notice of cancellation of registration. 21 days from the decision, the cancellation will take effect. Section 3J, notice of cancellation of registration. After the director makes a decision, the applicant has to be notified, and if this person is employed by a care home, the responsible person of the care home needs to be notified as well. Members made comments on the amendment for elderly care homes, so we are proposing this. So the responsible person, the operator, will also be notified, and details such as the appeal will also be set out. Section 3K to be inserted. When a director rejects or refuses to renew a person's registration, if the applicant disagrees, the applicant can appeal to the Secretary for Labor and Welfare. Section 3L to be inserted. When there's an appeal, and the registration is due to expire before the conclusion of the appeal. As long as a decision hasn't come out, the registration will remain valid until a decision comes out. Please carry on. Section 3M, application for registration as registered home manager provisional. Similar requirements apply. Under Section 3M, the director considers whether someone is a fit and proper person. The factors to consider are similar to those for consideration of whether someone is a fit and proper person for a home manager. For the provisional home manager, there's no specification on work experience and qualification. This is the key difference with a home manager. Section 3P, the decision needs to be made in writing to the applicant. If it's a rejection, the reasons need to be stated and the avenues of appeal need to be stated. Section 3Q, validity period of registration. The validity can only be 2 years, less to be decided by the director. Section 3R to be inserted. Home managers registered before the material date. These home managers, if they want to renew their registration, they can only extend their registration by up to 2 years, and they can only renew it once. Section 3S to be inserted. The director arrives at a decision to renew the registration. The renewal decision until the director arrives at a decision, the existing registration remains valid. Section 3T to be inserted, cancellation of registration as registered home manager provisional. Similar factors apply for home manager. The director looks at whether the registration was obtained by fraudulent means, whether this person is still discharging the responsibilities, and other similar factors mentioned just then. Restoring call. A question about registered home manager provisional. They are less experienced than home managers. Is there anywhere in the regulation that says these provisional home managers have to specify something in their post title or the name card that they are provisional managers? This is part of someone's qualifications. The average person goes to a care home and they see a home manager. Members of the public have expectations of these home managers. So for provisional managers, do they have to spell out that they are provisional managers? There's a reason I'm putting this question. You need experienced hands running a care home. If you have a provisional manager running a care home without specifying they are provisional managers, then you may have misunderstanding. For provisional home managers, they have a separate register at the Social Welfare Department. For registered home managers without provisional, they have another register. Members of the public who want to look someone up, the register, they will be able to tell whether this manager is provisional or not. But we're not specifying in this bill that a provisional home manager has to tell everyone they are a provisional manager. But people can look up a particular manager and see whether someone is provisional or not. Chair, I'm not asking the government to put it into law. We just need some kind of code of practice, some kind of guidelines for employees. This is important for the public. Members of the public need to make sure that the person running that care home is an experienced home manager. There's a difference in the requirements between home manager and home manager bracket provisional. So the government needs to find a way to show everyone clearly that whether this manager is provisional. The difference between a provisional manager and a manager is that the manager has more training and more experience. This point should be made clear in any future guidelines in the industry. Please carry on. Section 3U to be inserted. Notice of cancellation. The director needs to inform the applicant and also the care homes operator in writing, setting out the effective date, the avenue of appeal. Section 3V to be inserted. If someone is aggrieved by the director's decision, this person can appeal to the Secretary for Labor and Welfare. The appeal mechanism is similar to what I just mentioned. Please carry on. Division 3, reporting requirements. Section 3W to be inserted. The registered home manager or registered home manager provisional need to report certain events. First, whether this person, or rather whether a charge is laid against the manager for an offense, whether there's any change in the qualifications, any change in name or correspondent address of the manager. Division 4, register of home managers. There will be a register of home managers. There will be a separate register of home managers provisional. The details will include the name, the correspondence address, and the registration validity period of a particular home manager. Say there's a change, a home manager has passed away or the validity has expired, these names will be removed from the register. For Section 3Y to be inserted, the director will make the register of home managers available for public inspection. We move on to clauses 78 to 86 of the bill. This has to do with the registration of health workers. These clauses are similar to the amendments to CAP 459. We did not have any registration regime for health workers, but now we have this in the bill. Clause 78, amending Section 4 of the Residential Care Homes Persons with Disabilities Regulation. So we're inserting the word registered before health workers in the regulation. Clause 79, amending Section 5 of the Residential Care Homes Persons with Disabilities Regulation. The register of health workers will let the public know whether someone is registered. Page 179 or Clause 80, amending Section 6 of the regulation. This is a technical amendment. This has to do with the registration of health workers. The director can impose conditions as appropriate. Please go on. Marked up copy, page 180, Clause 81, amending Section 7 or Regulation 7. The director has to notify the applicant in writing, similar to the change in home manager. If it's a rejection, the reason has to be stated. There's a new requirement, Section 7, Bracket 2. If the application is approved, the notice has to say the validity period. This wasn't there, so we now inserting this part. Clause 82, amending Section 7A, 7B of the regulation. The new provisions have to do with the registration regime, Section 7A, to be inserted. This sets out a way to renew the registration as registered home health worker. Page 181 of the marked up copy. The director has to notify the applicant in writing of the decision. If the application is granted, the validity period has to be stated. If it's rejected, the reasons for refusal and the mechanism for appeal have to be stated.
New Section 7C. It sets out that registration remains in effect pending determination of renewal application until the director has made a decision on the renewal application. New Section 7D, it sets out the validity period of registration or renewal application. It would be decided by the director and must not exceed 5 years. Page 182, clause. The clause in the bill will amend Section 8, that is concerning the cancellation of registration as registered health worker by the director. Conditions include that the registration was obtained by fraudulent means or that the person no longer meets the requirement for the registration or that the person has contravened a condition imposed by the director. And also, the person may fail to comply with the reporting conditions. For health workers' registration, the health worker can make a written request to the director for cancelling the registration. Or if the person is no longer a fit and proper person under Cap 459A, and consequentially, the registration under Cap 613 will be cancelled. Brackets 3, the cancellation will take effect on the expiry of 21 days after the day on which the director gives the notice to cancel the registration. Another clause amend Section 9 under the RCHD ordinance. These are technical amendments only. Page 184 of the markup copy, clause 85 of the bill, replacing the existing Section 10 with a new Section 10. This is the arrangements in terms of making an appeal to the Secretary for Labour and Welfare. Brackets 1, if the director decides to refuse to register a person or to refuse to renew a person's registration or cancel his registration, the person may, by written notice, appeal to the Secretary against the decision. The notice must state the grounds of appeal, and also there is a deadline. Please continue. Page 185 of the markup copy, clause 86, adding new sections 10A to 10D. New section 10A sets out that the registration will remain in effect pending determination of appeal. So if an application has been rejected or registration cancelled, if the registration would expire before the decision is made, then during the period pending determination by the director, the registration will remain in effect. New 10B, a registered health worker must report to the director if something happened. These include a charge being laid against the health worker, conviction of an offense, or a change in the name or correspondence address. New Section 10C, it relates to the transitional provisions relating to registration before material date. Now, the registration that has effect immediately before the material date expires at the midnight on the last day of the 5-year period, beginning on the material date. 10D, application for registration as registered health worker pending on material date. So the deadline would be 3 to 6 months prior to the expiry date. Under the transitional arrangement, it would be at least 6 months before the 5-year period beginning on the material date. Now, if the application has been made before the material date and a determination has yet to be reached before the material date, then the new requirements under the ordinance after the passage of the bill will apply to that application. Now, page 187 of the markup copy, clause 87 of the bill, amending section 11 of the RCHD ordinance, section 12 as well. They are textual amendments. So before the first anniversary date, after the material date, an operator must employ a home manager and a registered home manager. So these corresponds to Cap 459. Page 188, amending the penalty, that is a level 5 penalty for any contravention. It corresponds to Cap 459. It is in response to the recommendation made by the working group. Mr. LAI Tung-kwok. Well, my question has been answered by the administration already. Please continue. Page 189 of the markup copy, clause 88 of the bill, amending section 12 and 13 brackets 3 of the ordinance. In case of any incompliance of maintenance of records or to provide plans, the penalty will be a maximum of level 5. Mr. Doreen Kong, Chair. I wasn't there when we went through the RCHE's ordinance amendments. I want to ask a question. What is the difference between plan and or diagram? Thank you, Ms. Kong, for your questions. Concerning a plan, on submitting the application for the license, we require a layout plan of the care homes, which specifies the layout of beds and rooms. Concerning diagram, well, may I get back to you later? Mr. Rincon, would you require an explanation? Yes, that's very important. On application for a license, well, there should be basic requirements so that residents can live comfortably. Now we have enhanced the penalty. So if the punishments are all level 5 for failure to submit a plan and a diagram, well, that would be unfair. I think the chairman is well aware of the difference because you are an architect. Now, plan and diagram carry different meanings. So by diagram, do you mean a simple sketch? Ms. Wong. Thank you, Ms. Kong, for your questions. For elderly people's care home or PWD's care home, on granting approval of license under the Code of Practice, we have a very clear we have a schedule, we have an annex stating the detailed requirements for a plan. In terms of scale and the manner of drawing, they are very robust requirements. So when considering an application, our teams of inspector, fire and building safety inspectors, as well as health inspector would go on site to carry out inspection. So this is something that is very close to our heart, and there are clear guidance on this. Thank you, Chair. Please continue. Page 190 of the markup copy, Clause 90, amending Section 14 of the ordinance. There are some inconsequential textual amendments, and also it sets out that an operator who contravenes the above offense concerning charging of fees would be liable to a fine as level 5. It corresponds to Section 36, brackets 1 of the amended Cap 459. Page 191, amending, that is Clause 91 of the bill, amending Section 15 of the ordinance. Textual amendments mostly to make the provisions clearer. It corresponds to Section 14A under Cap 459. On contravention, the maximum penalty has been raised to level 5, similar to 459. Mr. LAI Tung-kwok. Chair, are we talking about the requirements for operators to ensure advertisements contains certain information? So you said page 190, but it seems that we are at page 191. Sorry, it should be 191. Now, 191, it is about the requirements for operators to ensure advertisements contains certain information. So you said these are textual amendments only, but I think they are very substantial amendments. Now, originally, it says an operator of a residential care home must ensure that an advertisement must contain so on, so on. Now, you have changed it to every advertisement published by or on behalf of the operator by a third party for promoting the residential care home. So you have also added the word every, that is every advertisement. So it looks like that the amendment is not just textual, but rather drastically widening the scope of the provision. And also you haven't given any definition for the word advertisement. So let's say a media outlet wrote a report or an article about a care home. Does that constitute an advertisement? Well, I think the court will have a very difficult time deciding that, because the article itself is about the care home. So by advertisements, how would you define it? Must an advertisement contain the license number and other details of the care home? Well, it seems that it is not just textual amendment, but widening the scope of the requirement. Ms. Wong? Thank you, Chair. So we are just amending the provision to make it clearer. For Section 15, brackets 1, it says that the operator of a care home must ensure that every advertisement published by or on behalf of the operator must fulfill certain requirements. Thank you. Well, she hasn't answered me. What about the definition of advertisement? Chair, I think the core issue is the word published. So if you look at media, news reports and newspaper, they would make a clear distinction between sponsored advertisement, sponsored article, or genuine news article. They would say the information was provided by the clients if it is client-sponsored. So I think that would be a clear definition for published. Well, I haven't got there yet, but you're right. Published would also constitute an issue. Now, the definition says published includes issue, circulate, display, distribute, and broadcast. Well, let's say a reporter interview me, then I say something, then it was put on the newspaper. So and then it would constitute issue, circulate, display, distribute, and broadcast, or either one of them. So the law must specify clearly what publish is. Not just the word publish, as I've mentioned right at the beginning. These are not just textual amendments, but substantial changes, and a drastic one at that. In the present version of the law, there is no mentioning of the word publish. So how would you define advertisement? Must I pay someone to publish my advertisement to fall under the definition? Well, you have said many things under the definition of advertisements, but it only says include. So in case of any legal disputes, the definition would be very uncertain.
Undersecretary. Publish is a keyword here. Promote is another keyword here. Say you have a journalist interviewing a person. An objective report is fine, but if this journalist is helping to promote a care home, then you have an issue. So the operator has to get this right. Is it just objective reporting, or is it an attempt to promote a care home? Deputy Secretary. The two ordinances, one covering the elderly, the other covering persons with disabilities. This is a requirement that is under Section 15. This is a requirement for the operator to specify that they are license holders in any advertisement. They cannot just prevaricate on whether they have a license. Unlicensed care homes are not allowed to put out advertisement. The point about this section is to prohibit care homes without a license to take out an ad. This amendment is to make sure that any care home taking out an ad has a license at that time. The member believes the amendment widens the scope of the provision. The provision is there to ensure a care home has the license every time it takes out an advertisement. Chairman, I note the government's aim, but the way this provision is drafted can give rise to disputes, and there is a legal loophole there. An operator does not pay a journalist, and then a media report comes out on a care home. It doesn't matter how the report is written. When someone breaches this provision, someone is at the risk of a level 5 fine. A criminal offense is involved in this section that can give rise to disputes. So for this section, can we rephrase this provision in a better way? All kinds of problems can come up. Undersecretary, we will look into the phrasing of this section to allay concerns. Ms. Doreen Kong. Section 15. Now we have social media. Mr. Lai Tung-kwok brought up the example of journalists. Say when members of electrical visit care homes, we take pictures, we say nice things about the care home, and then the story goes into the news. Should we be more careful given social media is all the rage these days? Deputy Secretary, we note the members' comment and we will look into this issue. I believe only licensed care homes invite others to visit the place or engage in publicity. But we will look into this section. We will look at the phrasing to see if we can improve the way it's phrased. But there could be the case that when a member of electrical visits a care home and they're not aware whether this care home is a licensed place, we can rule out this possibility. Let's move on. Page 192, clause 92. Inserting section 15A. This is about a person who is employed by an operator of a residential care home for PWDs. Clause 93. Home managers in breach of the requirement to submit a register will be subject to a higher fine at level 5. This will be in line with section 36 bracket 2 of the amendment to the other ordinance. Page 194 of the marked up copy, amending 17(9)(g). This is an amendment mirroring the change to the other ordinance. This has to do with the restraints. 17 bracket 2. Adjusting the fine upward in line with section 36 bracket 2. Ms. Elizabeth quote. Section 17 bracket 1 bracket I. When the resident files a complaint and the remedial action, a record needs to be kept of these developments. But this is just about record keeping, no follow-up action. Sections 18 and 19 say that the home manager has to report these certain events such as infectious diseases. Chair, parents of children at care homes for people with disabilities are complaining. They take a complaint to a home manager, but then they are worried about harsh treatment or poor treatment of their kids at those care homes. Some say that complaints are futile. They get them nowhere. So can we insert another requirement apart from record keeping for complaints? Can we insert a requirement that these complaints need to be submitted to the director as well? The complaints may end up nowhere. What will be done about the complaint? Ms. Wong. The section here says the home manager has to keep records. We have professional inspectors. We also have social workers. Different professionals are involved. First of all, we look at what the complaint is about, and then we will have the professional inspectors visiting the care home. And even in the absence of a complaint, we have regular inspections, surprise inspections. So there are surprise inspections even in the absence of complaint. These inspectors look at how complaints are handled, and they check whether records are kept and how complaints are handled, and then we provide advice to the care homes. When complaints are received, we also compile reports on those complaints at the licensing division. Of course, when someone comes to the social welfare department with complaints, the department takes action. But many parents are worried. They have no idea where to take their complaints. They may not come to the SWD. They first take their complaint to the home manager. But then they feel that the complaining is not getting anywhere and they fear potential reprisals. The home manager needs to know that actions need to be taken. The department becomes aware of complaints only when inspections are made, but there's no requirement of home managers to report those complaints to the director. If such a requirement is in place, the parents are in a better position. So the home managers cannot just cover up any complaint received. The record keeping is required, and the social welfare department looks at the records. That's part of our review of the entire care home. We look at the records, whether the records are kept and whether actions are taken. This is a key part of management. Our licensing branch receives complaints. We appreciate the concerns on the part of parents. If parents want to take their complaints to us without informing the care home, we can do that. We work with our complainants on those matters. Any follow-up questions from Ms. Elizabeth Kwok? Whichever way it's done, the social welfare department has to get involved. The government needs to allay the concerns of potential complainants. Before I invite Ms. Kwok to continue, I want to say that we're almost out of time, so I will extend the meeting by no more than 15 minutes. Let's try to cover as much ground as possible so that at our next meeting we can go into the government's response to the follow-up questions. Section 17, bracket 1, bracket A to bracket I. The changes are technical amendments and the change to the fine. If the existing practice is working just fine, I won't be receiving so many requests for help or complaints from parents with kids at LCHDs. The complaints I receive point to inadequacies at the RDCHDs. We want to see ways to fix the existing problems so that the home managers are made aware that they cannot just sweep the complaints under the carpet. Chair, I'm raising this point because we are confronted with all these problems, and these are the things for the government to consider. Ms. Wong? We will continue to enhance our mechanisms for dealing with complaints.
Now, page 194, 96, 94 to 90, clauses 94 to 96 of the bill, amending section 18 and 19. For home managers who have contravened and the requirements to provide information or report a scheduled infectious disease, and they will be subject to a maximum of level fine punishment similar to 459. Clause 97, amending section 23, enhancing the minimum area of floor space required for each resident. It is in correspondence to Cap 459. Page 196, Clause 98 of the bill, amending Part 7, the title of the ordinance to better reflect the contents of the parts. It corresponds to the title of the corresponding parts in Cap 459. Clause 99, amending Section 29, a textual amendment, corresponding to Section 28 of Cap 459. Page 197 of the markup copy, Clause 100, amending Section 32 and 33. The penalty for obstructing a member of the Fire Services Department to exercise the power to inspect the premises has been enhanced to level 5, corresponding to Cap 459. Clause 101, amending Section 34 of the ordinance to replace the existing Section 44 concerning administration of medicine. It is in correspondence with the amendments under Cap 459. A moment, please. Ms. Lillian Kwok. Thank you, Chair. I have a question. I'm not very familiar with this part. In many legislations or in many sessions, you are raising the maximum level of penalty from level 3 to level 5. So I would just like to know the exact amount of the respective fine level and what have you considered in terms of raising the fine. Thank you, Chair. Level 3, $10,000. Level 5 fine, $50,000. We are amending the level of fine in response to the recommendations made by the working group in their report. They have reviewed the offences and all the punishments under the ordinance. A report has been compiled concerning the offences that they want to make more deterrent. Thank you, Chair. Follow-up question. How do you define that? You are raising all the punishments from level 3 to level 5. So why have you adopted such an across-the-board approach? Well, level 4 is $25,000 fine. The rationale is that by raising the fine from level 1 to level 2, or from level 3 to level 4 by one level, the deterrence effect may not be sufficient. And also, we want to give courts more room to maneuver so that for more serious offences, a heftier sum can be imposed. So is level 5 the maximum, the highest level? Deputy Secretary. Well, we also have level 5, $100,000 for unlicensed operation of care homes. We haven't set a maximum fine level. The maximum amount of fine would be $1 million because that would be a very serious offense. Under this ordinance, unlicensed operation of care home would carry the highest penalty. Thank you. Let's continue. Page 199, Clause 102 of the bill, amending, adding Section 34A and 34B concerning the use of restraints and also protection of residents' dignity and privacy when providing care, etc. The amendments correspond to corresponds to Section 39A and 33A and 33B under the amended CAP 459. Mr. Rin Kong. Chair, I have a question about Part 7. Now, Part 7, it was called Precautions Against Fire and Other Risk previously. Now, the title covers a much wider scope. That is residents' health, safety, and well-being. Well, well-being is a very broad thing. So why have you decided to include these three components in the title? Well, under the epidemic, many care homes for elderly people and PWDs, the family members told me that they had a lot of difficulties visiting the family members in the care homes, despite the easing of the epidemic. So is there room for us to include a reasonable visiting rights in the ordinance in terms of visiting hours or length? Now, since you are including the term well-being in the title, well, visitation rights is also a very important component under visitation rights is also very important to residents' well-being. Under Secretary, thank you. For care homes, we have adjusted the visitation arrangements recently. We understand that visits by family members are very important to elderly people and persons with disabilities, but we have to balance the health risk in terms of visiting measures, especially interactions including feeding, which carries higher risk. We have certain restrictions. So we haven't imposed a restriction on the number of visits paid each week. So in our letter to care homes, we have given care homes the authority to assess their own arrangements. So we are balancing the needs and the health risks. Thank you. I welcome the Undersecretary's answer that there is no restriction. Well, according to many family members, however, in practice, the care homes would tell the family members that your visits are obstructing my work because we don't have enough manpower. That is when COVID-19 was in the picture before. So if you have included this visitation rights in the ordinance, the care homes would pay more attention to that. Well, since your inspections are not very frequent, the care homes may give family members a hard time when they come to visit because they think the family members are obstructing the work. Well, actually, the family members have had a very difficult time in visiting their relatives. So what is the direction in this regard, Under Secretary? Well, concerning the number of visitors, we have some requirements. And also we require COVID testing for visitors. And we don't want residents to engage in mask-off activities outside, say, for example, eating outside the facility. But we have pay attention to the need of the families. So what if there is no COVID? What is the general direction in terms of regarding visiting? So I understand there may be the visitation arrangements may be adjusted under extraordinary circumstances, say COVID. But what about other than COVID? Are there guidelines in place so that visitors and family members are aware of their rights? SWD, please, Ms. Wong. Thank you, Chen. Thank you, member. Well, under the epidemic, like Mr. Ho said, it depends on the directions given by the Health Bureau. We want to safeguard the health of residents, so there are guidelines in place. Every time when adjustments are made, we would send a letter detailing the arrangements to the care homes. Well, in an epidemic-free environment. I think all care homes want their residents to live happily. So in terms of visiting arrangements as well as operation of care homes, family members should have engaged in discussion with the care homes. Well, if the visitation rights are obstructed by care homes, or if care homes give family members a hard time, well, feel free to approach the SWD. We have a team to facilitate communication between family members and care homes to reach a better arrangements. Thank you. So members, the meeting has been running for a long time today. So I will stop the clause-by-clause scrutiny here. We are now at clause 104, section 34A. We will continue on the next occasion. I think we will be able to complete all clause-by-clause scrutiny the next occasion, because these are mostly technical amendments and which have been broadly discussed previously. And members have raised some issues today which require administration responses and study. So Mr. Lai has raised a question. I think Mr. Dai, the law of draftsman, has yet to give him a response. Well, concerning sole proprietorship, under this management model, according to the government's response to the electrical, there are many legislations mentioned with similar wordings. So Mr. Lai's question was whether sole proprietorship was mentioned in these legislations. Well, my answer is no, but I think the principle applies. Mr. Lai Tung-kwok, are you happy with the answer? Thank you, Mr. Dai, for your swift work to confirm my suspicion. Well, since we are not comparing them apple with apple, we have to look at the actual effect of the bill and assess the implication. By adding a few extra words, the implication may be much wider. But there may be unexpected effects. So I think we have to go back and look at whether there will be plausible problems. Thank you. I also invite the administration to submit the proposed amendments as soon as possible so that we can have time to study the amendments. Sufficient time should be given to members. Concerning the date and time for the next meeting, the Secretariat will notify you of such in due course. I want to allow more time for members to study the government's response to our concerns, as well as the proposed amendments to be moved by the government. Time is needed for this step. So if there are nothing else, I adjourn today's meeting. I thank members and officials for your participation.